Well, in a non-subscriber case, what the injured employee has to show is that the employer was somehow negligent in how they were injured. Either the employer failed to do something or actively did something which was the direct result of the injury to the employee. Now, non-subscriber cases are a little bit different from what we call straight negligent cases. In a non-subscriber case, by Texas law, the employer is stripped of all defenses of comparative negligence or apportionment of fault. All the injured worker must show is that the employer was 1 degree of negligent in how they were injured, just 1 degree, and the employer is responsible for 100% of the injury. There is no comparative fault analysis in a non-subscriber work-related injury case pursuant to statutes. 406-033 of the Texas Labor Code provides that an injured worker who works for a non-subscribing employer must only show a degree of negligence. The only defense that the employer would have is that the injured employee was 100% the sole cause of their own injury, or that some other third party disassociated from the employer was at fault for the injury to the worker. The employer is stripped of any other defense. So in proving negligence in a non-subscriber case, from a legal standpoint, is simplistic. It's easier. The legislature developed it or designed it that way. They wanted to communicate to employers in the state of Texas that we are not going to force you to pay an expensive premium for real workers' comp insurance where you can never be sued. We're not going to do that. We're going to try to persuade you by inserting a poison pill into the statute, which says, look, you can be a non-subscriber if you want, but if the injured employee can show that you're 1 degree of negligent in how they were injured, they can bring a negligence claim against you and bring it into the courts. For more information, go to AaronAllisonLawFirm.com.